Well, good morning and happy Thursday, and welcome to this week's edition of Offit Kurman's Remote Rundown. I'm Jim Reese, Director of Business Development at Offit Kurman, and each week I am joined with labor and employment attorneys Russell Berger, Sarah Sawyer, and Veronica Yu for a conversation about the latest and most relevant employment issues related to COVID-19 and advice for owners and employers on how to best deal with these issues. We had a spirited conversation last week, and I know you guys have a great topic for today. So Sarah, why don't you kick us off?
Sure, thanks, Jim. So through the COVID pandemic, a lot of employers have been really focused on everything having to do with COVID, as they should be. But there's definitely been some other developments in employment law over the last couple of months. And there will be more to come coming up in October with some new changes to Maryland laws. So I wanted to dive a little bit today into some of the other things that employers should be considering, as if they don't have enough on their plate with COVID-19, but it's important to be paying attention to some of these other things as well. So kind of starting at the federal level, there was a Supreme Court decision that recently came down, a 6-3 decision. It's called the Bostock decision, and it has to do with gender identity and orientation and whether that is a protected, Title VII, if it's protected under Title VII. And so the court did find that it is that discrimination for gender identity and orientation is covered under Title VII. So that is something that employers need to be thinking about when looking at their policies and procedures and how they're treating people. So that's something that is brand new and should be considered. A big thing that this impacts is potentially dress code policies and making sure that you've got gender neutral dress code policies and that you're not, this is something that we advise our clients on often before this decision. But that, now in light of this decision, it's something that employers really need to pay even more attention to, especially if you're going to be trying to have a policy that is gender specific, that first of all, that you can back it up and for a reason why that is. And most times there's not going to be a good reason for that unless you're in a very specific industry where you can really make the case for the fact that men and women should be dressing differently. And even if you are able to make the case that men and women need to dress differently for some reason, that you want to make sure that the policy is enforced in a way that you're enforcing it for the person's gender identity, not their assignment at birth. So that's something to be considering as well. And then as far as neutral policies are concerned, it's really talking about just a broader policy regarding professionalism and making sure that people are adhering to proper grooming standards and things like that, but not getting granular and very specific in what men should wear, what women should wear, and really moving away from some of those more specific things that could be seen as, being more harsh towards women or more harsh towards men, or, dealing with some of those issues.
Yeah, I'm glad you said it's something that we've been counseling on since prior to the Bostock decision, because it really is. Title VII says you can't be discriminated against in employment on the basis of sex. So really what the case decides is what does on the basis of sex mean, and that's been with respect to sexual orientation and gender identity. That hasn't been entirely clear. Certainly there wasn't a prior Supreme Court decision on it, but there were appellate court decisions. Different states and localities had their own versions of Title VII that made gender identity and orientation explicitly protected classes. So, I think what this does, at least from my perspective, is it clarifies a rule that, I frankly kind of thought was the rule anyway. I agree with the decision of the Supreme Court. I think it's well written and intelligent, just in interpreting what on the basis of sex means. Because essentially what they said is, if you're a man and you love a woman, and you don't get discriminated against, but if you're a man, you love a man, you do get discriminated against, like that's on the basis of sex. The only difference there is the sex of the person who's the employee. So, I think that's kind of like the logical interpretation of what the law says. And it's frankly kind of where we've been steering clients for a while. And certainly, as you point out, I think it's going to creates more potential for pitfalls now that a potential plaintiff doesn't have this concern about whether or not it might apply. A defendant no longer has an argument to say, well, it doesn't really apply to orientation. Now that's all clear. And so I think, I think it's a good thing for employers to think about is, man, like now that there's a clear path to this, which, the runway's been cleared, I really have to think about how all my policies potentially impact people, not just along their born gender, but their gender identity and their sexual orientation.
Yeah, and I think there's also the practical aspect of it, that getting really granular on these policies and, again, just specifically related to dress code again, I'm just kind of returning there, is it's the practical piece as well of just causing, frustration and things like that. And most of the time it's not necessary. And so leading up to this, as you mentioned, there's a lot of states have already addressed this issue. A lot of courts have already addressed this issue, and now it's the standard, and now it's out there in the public eye more, and everyone's more aware of it. So it's really thinking through all of those pieces and really looking at everything with a critical eye and saying, why do I have this policy or procedure, and is it impacting people, in a way that it shouldn't be, and both from a practical and from a legal protection standpoint.
And I would just add, we're talking about employee handbooks and policies, really. And, we're talking about how to make sure these are neutral and don't reflect on one gender one way or the other. But I think it's also important to remember that the culture of your company always comes into these policies as well. So there isn't always a cookie cutter policy that we can use. Like, we can take into account the culture of your company and what you guys are doing to make it more specific for you. So we can definitely take that into consideration as well.
Yeah, and as we're kind of talking about the handbook and the policy component of it, there's a Maryland law that changed or that is going into effect in October, and it's generally referred to as the Crown Act. And essentially what the Crown Act says is that it specifically prohibits discrimination on the basis of a protective hairstyle. So that includes things like braids, twists, and locks. And the new law that Maryland's enacted also goes on to make clear that race, as it's used in Maryland's anti-discrimination statute, includes traits associated with race, such as hair texture, afro hairstyles, and the aforementioned protective hairstyles. So effectively, what this new law is doing is it's making certain hairstyles, which are associated, with people of a certain race, making discrimination on that basis prohibited. So what we're recommending is, if you have a handbook, you've got an anti-discrimination policy in place, 9 times out of 10, it probably doesn't already mention hairstyle. So, that's something that you should go back and revise in your handbook to include hairstyle and include, the language that the new Maryland law really necessitates. Go ahead.
I was just going to add, a lot of handbooks will have that general catch-all in the EEOC policy that all protective classes pursuant to applicable law, will have that general catch-all language if changes like this happen, and you can't change your handbook right away. But I think, as Russell pointed out, it's really important that we're aware of these changes, and you're also speaking to management and supervisors that have to implement these policies so that they're aware of these important changes.
Right. I mean, definitely update your handbook, but if you don't get to it for a few months, the law is still going to apply. So comply with the law, number one, change your handbook, number two.
Hey, Russell, what about hats with hair?
I don't.
Is that covered in the new policy?
No. So watch out, Jim.
Okay. I have till October 1st. Okay, thank you.
Uh, Yeah, so one of the other changes in Maryland law that I think bears discussion right now, especially given, I know this is what we missed while we've been paying attention to COVID, but this ties back into COVID, is Maryland is also enacting a mini WARN statute. So WARN is a worker notification statute that when you, at the federal level, that when you lay off a certain number of people or you close a plant or a facility, an office, there's certain notice requirements that go along with that, advanced notice requirements. So you have to give people a heads up that there's going to be a mass layoff or a factory or an office is going to close. And that at the federal level, that has certain thresholds as to what triggers it. So what Maryland is now enacting is a law that functions in pretty similar in practice, but it lowers the threshold. So it's going to require more employers that are laying people off or closing down an office to provide advance notice. So the key points, and warrant compliance can be fairly complicated. So really what you as a business owner, as an employer want to be thinking about is, do I have to comply, or what might I have to comply? What should I be thinking about? So it applies, the Maryland law is going to apply to employers with 50 or more employees. And again, lawyers argue over what that means. So it can be more complicated, but as a baseline, it's 50 or more employees, and the notice requirements are going to be triggered when there is a layoff or a plant closing that involves at least 25% of those employees or 15 employees, whichever is greater. So, if you're laying off 15 employees because you have a COVID compliance, or you have a COVID related reason to do so, you may be covered by the Maryland WARN. And we looked at it, we had this issue back in the spring with the federal WARN. There's exemptions, there's all sorts of nuance to compliance and whether or not you have to comply when sudden financial circumstances come into play. But the simple point for right now is, if we're planning on COVID being a 3-month issue, and now you're looking at it being a 6-month or a year issue or whatever it ends up being, and you need to make a change to your workforce, you may very well have to comply with the Maryland Mini WARN Act. So it's something that bears just at least having a conversation with legal counsel about, so that you can be thoughtful about it, you can plan it out, and you can make sure you don't step in any potholes.
Yeah. So Russell's mentioned 2 out of 3 of the big employment changes that are coming in Maryland effective October 1. So I'll just quickly mention the third, but Maryland has amended their Equal Pay Act to include a salary history ban and salary inquiry protections. And basically what that means is employers must provide the wage range for the position in question upon the applicant's request. So that's definitely new. And at the same time, the law prohibits employers from seeking an applicant's wage history, which is also very new in Maryland. So these 2 things are going to counteract for applicants, and employers are prohibited from retaliating against any applicant that either requests that wage range or refuses to provide their prior wage history. Again, this doesn't, it's new. It doesn't stop an applicant from voluntarily sharing that information. And the law does say that employer can consider the wage history to actually provide a higher offer than they would have without that information. But you do have to be careful of pay disparities between the sexes or gender identities. So it's just another thing that employers have to consider this fall. And my takeaway for today is it's time to review handbooks again, even though we're dealing with everything COVID related, and specifically with the salary laws. You want to analyze your employee compensation and really make sure there are no major disparities between employees in the same position, and prepare to create some sort of formal salary ranges for all positions.
Yeah, so, and I would add, just in terms of takeaways and next steps for business owners, we just kind of threw 4 big topics at you during this session as to things that are changing, things that are evolving in the law. So while you've probably been paying more attention to employment issues because of COVID than you might normally do, and now's a good time to kind of catch your breath from the COVID and think about these other compliance issues that are going to be on your radar. And just we've been drilling down on COVID issues for so long. Don't stop thinking about employment issues, but you can come up for air and think about discrimination and compliance issues.
Yeah, and kind of in the vein of coming up for air, I'm experiencing with my clients and just even family members and their jobs and things, people are experiencing a lot of fatigue over COVID-19 and employment issues in general, because obviously this is a lot to keep up with, but really continue to tap your resources is really my takeaway as well, is that, there's a lot of, there's the things we covered today that are coming up and the changes and things are always changing. And we've got the things changing with COVID, and then now we've got these other things that are always changing in the background that are kind of cyclical. And, October is always a time where Maryland's making changes to the laws based on prior session. And so that's something that we would normally be looking at in a pre-COVID world. So there's always, there's a lot here. And I know speaking to my clients, it can be somewhat overwhelming because there's a lot of man hours going towards COVID issues right now internally. So don't be afraid to tap your external resources and offload some of those things, and just stay in touch with your subject matter experts, whether it be your lawyers, your accountants, different resources that you have, and that can be a good solution to kind of deal with some of that fatigue around some of these issues.
Well, lots of information. Non-COVID-19 related. So you're right about the COVID-19 fatigue. This was great information regarding employment issues, discrimination, compliance, etc. Time for our fun trivia question. We'll start with Sarah. And the question is, the use of social media has skyrocketed during the pandemic. And I'm curious for each of you what your go-to social media platform is: LinkedIn, Facebook, Instagram, TikTok, etc. And what you're maybe going to give a try out and test while we're in the pandemic. A lot of people are testing some other social media platforms. So Sarah, what have you been using?
So I have avoided TikTok somehow, though it sometimes crosses my path and other platforms. I know my husband's gotten into TikTok during COVID. I'm pretty much Instagram. I like that it's a lot of pictures, and I follow a couple. I think I had mentioned in a previous episode. I really like Sarah Blakely, and I follow her, and I really like her content. So I like that, and it's fun to see. I have a lot of like dogs and cats and things that make me smile on my feed. So I've been sticking with Instagram. My dog may have an Instagram, so that's my platform. My platform of choice. Saucy Alfredo, if anyone's interested.
Okay, Veronica, how about you?
Yeah, I had to go with Instagram too. I like that it came a little later in my life, so the people I share with on there are a little more up to date, and you can kind of cultivate your likes to kind of where you are in life right now, as opposed to where I was on Facebook in 2006 when I first got. So there's a lot of differences, and I'll just have to say I had to Google what TikTok was, so I guess I'm getting old.
Russell, is she getting old?
Not as old as me, because I was going to say
always look up to Russell.
Yeah, I was going to say MySpace.
No.
Put all of you guys in my top 8. But seriously, I use Twitter as kind of like my cultivated news source. I'm probably not like scanning the internet or watching a ton of TV, but it's kind of my cultivated news, whether it's more substantive news or sports news or where they intersect. Now that tends to be where I get my news. And then, but I'm not a tweeter. I'm not active. I would I save that for LinkedIn. So which I suspect is your answer, Jim.
Yeah, 100%. Although I'm definitely in that category of Facebook users, because it seems like the kids are off of Facebook and their parents are now on Facebook. But I like the platform. Well, thank you, everybody. Great session today. We'll see you next week for another edition of Remote Rundown, and have a great rest of the week. Enjoy your Thursday.
Thanks.
Thanks, Jim.